What's up, Ali, Benji? What's up to all my co-counsels? All right, let us get started. We have a lot to get into today, okay? The Karen Reed trial is underway. That was really exciting. And then we have a verdict in Lori. I did not watch the verdict, so these are my initial erection. We don't want an erection, but my initial reaction, okay? And I think I pretty much know what the verdict is, but let us see. Let us see. Let us hear it from the horse's mouth.
Where's the state?
All right. Come on, Judge. I hope you guys had a good day today. All right. So Benji is excited. Let's see.
The parties are.
Okay, hold on. I just need to watch Miss Vallow Daybell. I mean, we're going to be seeing her soon unless she decides to enter guilty plea. She's out there with her court files. All right. Now, I'm sorry I'm late. I had to get my...
The jury's not present. We were informed about 45 minutes ago that the jury has reached a verdict.
Okay.
In the event that the verdict is not guilty, this trial will conclude. In the event that there's a guilty verdict, we need to move on to an aggravation phase immediately after the reading of that verdict. I've given the parties proposed aggravating circumstances, instructions, and proposed verdict form.
I'm about to
And the
sneeze.
defense both have a chance to review those.
Yes, Your Honor.
Are there any additions or corrections from the state?
No, Your Honor.
Okay.
How about from the defense? The defense did email my staff requesting an additional paragraph. The defendant is not required to testify or produce evidence of any kind. The defendant's decision not to testify or produce evidence is not evidence of any aggravating factor, which I did include in the bottom third of page 3.
All right, Lori.
Given that, are there any additions or corrections?
No, Your Honor.
Are either the state or the defense requesting any other additional instructions?
No, Your Honor.
If there's an aggravation phase, does the state plan on introducing any testimony or exhibits?
Testimony, I believe.
We'll get there. We'll get
from
there.
2 family members, we will limit it.
Okay.
I don't plan on doing openings, just presenting testimony and then argument.
All
All
right.
right. Would the defense anticipate presenting any evidence?
Your Honor, can we just stipulate to that? I mean, the statute says there's only one punishment for this crime. What is this?
What is going on, Lori?
Why is there an aggravation phase for this specific count?
Much like the guilty verdict,
You had a lawyer. If you had a real lawyer, the lawyer would have answered that for you.
jury in Arizona has to find whether or not there's any aggravating circumstances.
Why didn't you ask 10 by counsel, Lori?
In addition, the jury would still need to find that if it's a guilty verdict, whether or not it's a dangerous offense. Until it's found as a dangerous offense, that sentence that you're talking about wouldn't be triggered. So I think we need to have an aggravation phase regardless. So would you plan on presenting any testimony or evidence in the aggravation phase if there is an aggravation phase?
No, but could I just stipulate to it or not? That's my question.
Okay, well, she's a little aggressive. It might also be nerves, of impending doom.
You can stipulate to aggravation and you can stipulate to whether or not it's a dangerous offense, but I think you should probably wait until we read the verdict to do that. So I guess it will, depending on what the verdict is, we may take another break. If there is an aggravation phase, are your witnesses here yet?
No, they are not here yet, Your Honor.
Why
Next
here?
dinner, from my understanding, about 5 minutes out.
Oh,
All right,
okay.
we'll wait a few more minutes before we take that.
No, stop waiting. So why'd you summon everybody? Hold on. I did not watch any of Lori's proceedings today.
All right, back on the record, State of Arizona versus Lori Daybell, CR 2021-001-704. The parties are present. I'm going to have my staff go ahead and line up the jury to wait in the
Okay.
hallway for a minute.
Sir. Ooh, hold on. Why are they showing? Are they showing all these family members? Are they showing the jury on camera? What's going on? Is that staff? 1, 2, 3, 4. Oh, those might be family members. All right. All right, come on. Ugh. Need them to put it on Lori. Lori, that's who you put it on.
All right, the jury is present. Please be seated. Do we have a foreperson? Who's the foreperson?
Yes,
Has the jury reached a verdict?
yes, we have.
I'm going to ask you to hand that to my courtroom assistant.
All right. Ellie's so funny. Ellie said hit the like button, okay?
I'll ask the clerk to read and record the verdict.
All right.
In the
Come on.
Superior Court of the State of Arizona in and for the County of Maricopa, State of Arizona versus Lori Daybell, CR 2021-001704-001,
Come on.
verdict count 1. We, the jury, duly impaneled and sworn in the above entitled action, upon our oaths, do find the defendant, Lori Daybell, as to the crime of count 1, conspiracy to commit first-degree murder occurring on or about July 11, 2019, guilty. Signed, foreperson. Is this your true verdict? So say you one and all.
Okay, where's Lori? Where's the
On the
reaction,
court's
Lori?
own motion, I'll go ahead and ask the clerk to poll the jury.
All right.
Yes.
Juror number 6, number 8, juror number,
Yes.
juror number 12, is this your true verdict?
Yes.
Juror number 13.
I mean, this is pretty much what a lot of us were expecting. This was a difficult, how do I put it? It was difficult as far as some of the presentation, but it still would have made a decent criminal defense case.
True verdict.
And Lori
Juror
ain't
number
do
15,
anything.
is this your true verdict?
Yes.
Juror number
Or not. So the admonition still applies. Please
Okay.
go to the jury room for a few minutes.
All right, for the jury.
All right, let's see what Lori has to say.
Indicated earlier,
She's
I'll
pretty
ask the defendant,
stoic.
you indicated earlier
No real emotion.
perhaps a willingness to stipulate to aggravating factors. Is that something you want to do, or do
Is
we
that
want to
big
go
book
through this
open?
aggravation phase?
I'm willing to stipulate to it, Your Honor. All that it is the dangerous phase. Is that correct? There's only one statute there's only one sentence.
Well, the jury would need to find, first of all, whether or not this is a dangerous offense first. Secondly, whether the offense
Lori, so why on earth did you go, Lori? Lori has me really puzzled.
caused physical, emotional, or financial harm to the victim, or if the victim died as a result of the conduct of the defendant caused a
I just, again, she's not a real lawyer, but I'm really puzzled by her decision and choice to represent herself when she has no real fight. I mean, she's not even fighting.
emotional or financial harm to the victim's immediate family.
Actually, right before I came up here, I was watching what is this? I was watching a short clip. I think it was shorts or something. And in the clip, it was Will Smith's wife. What's her name? Jada Pinkett Smith. She was being interviewed by some folks. I don't even know who. Anyways, in the comments, somebody said that Jada Pinkett Smith was the epitome of functional insanity. All right, that's a term, functional insanity. Because Lori,
And then
Lori,
thirdly, the offense involved the presence of an accomplice. If you're willing to stipulate to all three of those, we can do that. If not, we'll bring the jury back in.
I'll stipulate to it, Your Honor.
All right.
Lori. So what was the freaking point? What was the freaking point? What's the point?
You understand that
I mean,
if you
she's done fighting. She's given up. She's thrown in the towel. You should have had an actual defense, have actual licensed attorneys representing you. Lori, it's just-
stipulate to this instead of a jury finding, well, let me back up. You understand the jury would have to find these aggravating factors beyond reasonable doubt.
Yes.
All right. And do you understand that if you stipulate to these factors
I'm just
instead of a
sticking around to see if she was sentenced or not.
jury doing it, I could also find additional aggravating factors at sentencing?
Sure.
That girl
anyone-
said, "Sure."
Forced you or threatened you in any way to get you to stipulate to these factors?
No.
Has anyone promised you anything to
Lori.
get you to stipulate to these factors?
No.
Have you had any drugs, alcohol, or medication in the last 24 hours?
No.
Do you agree that pursuant to the jury's verdict of guilt, that this would be a dangerous offense because a deadly weapon or dangerous
Shout out to
instrument was
all the
used?
real lawyers.
I'm stipulating
Next
to it.
chart, and I
You
want
agree
a
that
real
that's-
lawyer.
That's what
All right.
that this is a dangerous offense.
Correct.
And you're further stipulating
And then
that as a result of your
I'm glad you can actually see me, Benji, because that is just I am so puzzled. I've definitely been face palming the whole. Literally, as I was saying this, I was literally touching my face. I'm just so puzzled. Lori has me stumped. Lori has me stumped. But then again, I do recognize that Lori is not mentally sound. I know she disagrees. She definitely disagrees. She's not mentally sound. And we did learn a term today, functional insanity. I'm just, what?
conduct,
What
at
the
least
hell?
the victim or the victim's family suffered emotional or financial harm.
Absolutely.
And you're also further
Okay, so
agreeing
Allie's
that the-
asking if the death penalty is on the table in this case. I do not know that Arizona has the death penalty, but I'll look it up.
offense involved the presence of an accomplice.
Yes.
Is the state
Lori,
satisfied with the colloquy?
I'm just what? Okay, so apparently Arizona does have the death penalty, and they currently execute by lethal injection. Okay, I don't know. More information than you guys need, but inmate sentenced to death before November 23 of 1992 had the ability of choosing either legal gas or lethal gas or lethal injection. 14 inmates have been executed using lethal injection since its implementation. Okay, I did not look up Lori specifically just because I don't want to jump ahead.
Yes, Your Honor, it appears it's no involuntary made.
All right, the court does
And I
find
did not know that death penalty would actually apply to a case such as this one because Charles, I don't exactly know that he's part of a specialized group of victims, but we'll find out.
that the stipulation to those three factors
You guys know I'm never really interested in sentence. It's not something that, not even really the verdict, but
was
not something
knowingly,
I'm interested in.
intelligently, voluntarily made, I will accept the defendant's stipulation. At this time, I'm going to bring in the jury and release them from the admonition. Before we,
Okay, and then Allie says that Lori is heartless. She has no emotion whatsoever. She did what she did, so it is what it is. Um, right. Under they did listen, they deliberated under I think the time when because I did not watch the actual deliberations, but there was a time when the Karen Reed trial was in recess, and I tried to switch over to Lori, and it was like what, an hour and 40 minutes or something along those lines. But yeah, they were pretty quick. They were really quick with this one.
Do that. Well, as my staff's lining up the jury, do you want to have a sentencing date within approximately 30 days, or do you want
Lori,
to wait until after the next trial to be sentenced on this matter?
What does the court prefer?
what, Lori? What on earth are you saying? What, oh, Lori, Lori. I'm so glad this trial is over, and I'm not going to have any more high blood pressure induced by Lori, because I am just so confused right now. I guess she's confused. I don't even know that she's confused. Her attitude's a little different, though. Her attitude is a little different in this moment. She has a different attitude.
Be sentenced on this matter.
What does the court prefer?
It doesn't matter to me. Maybe
Lori, you are the defendant. And even if you were not the defendant and you were a real lawyer, that's not up to the judge. It would be up to your client and what's in your client's best interest. So, Lori, in this moment, you're supposed to be thinking about your best interest. Oh my goodness, Lori.
want to talk to your attorneys or advisory council
She has no lawyers
about that. We don't have
Yeah,
to do
and it appears that Lori actually does not consult with standby. I mean, I was over here. She could have reached out to me. She does not consult with anybody. It seems like she's just been doing whatever it is she wanted to do when she kind of, I guess that's how things have been going in her life.
right now. Well, you can do it in a few minutes.
Oh my goodness, Lori. What on earth? Hold on, I have a video idea, so I just need to I'm gonna have to type this out quickly. I have a video idea.
Meaning
Right, hold on.
your jury service. Members of the jury, you are now released from the admonition. This concludes your jury service. I want to thank you for your jury service in this matter and your attention in this matter. The admonition is lifted, meaning you can talk to anyone about any aspect of this case that you want to at this
I don't
point.
even know that I'm interested in, the jury interviews. There have been cases where I definitely wanted to know what the jury was thinking, but in here I'm like, come on, Lori, it was kind of clear, but this still would have made a pretty decent criminal defense case.
But you also have the right to not talk to anyone about any aspect about this case. I just need to take care of a few more matters, but if you want to wait for me in the jury room, I'd like to thank you personally.
All right.
And then you can be on your way. If you don't want to wait for me, that's fine as well. But you are
trying
released
to go home
at this time. All right. Thank you.
But this all worked out because I was worried about the Karen Reed and Lori Vallow Daybell trials commencing on the first day, and it actually really worked out. It worked out.
Do you want to talk to your advisory councils briefly to discuss whether or not you want to proceed to sentencing or wait until after the next trial?
If we could just wait till after the next trial, Your Honor.
Okay.
Okay, Lori, next trial, please do not represent yourself. Whatever on earth you do, you've kind of messed up things already. I mean, you messed up. She messed up a long time ago. She messed up way back in 2018, 2019. At this point, she's not. I don't even know. I don't even know if an appeal court can come to an aid. Lori's just don't kill people.
So I'll hold off
right?
on ordering a pre-sentence report until we resolve the next remaining case. I've already set
When
the
is that?
dates and we have a status conference in mid-May on that.
Okay.
So unless there's anything else from the state's
Oh
perspective.
my goodness. Lori, Cox, Vallow, Daybell. I'm sure they are the last names. They are the last names that
From anything else from
I
your
don't
perspective?
remember right
Nope.
now, but
All right, we'll be at recess on this matter.
Lori was. I'm so stumped right now. I don't even know. Is she laughing? Lori, is she smiling? I guess this was expected. It was definitely expected. She's having a good time, or she's chuckling, or maybe that's just again functional insanity. That is the phrase, functional insanity. What on earth, Lori? All right, I'm just trying to watch the court officers take her in. Yeah, she's not okay. Lori's not okay. That nobody can convince me that Lori is mentally sound. That's just that woman's not okay. Lori's not okay. Standby counsel is like, ooh, on to the next one. Yeah, Lori is not okay. Add somebody that's definitely not fine. All right, let us move into. Oh, is that no? I'm getting distracted. Stick to the schedule. All right, let us get into what does it say 1 day ago? Isn't this today? I mean, I watched it from the very beginning. I missed. Yeah, there we go, 11 hours ago. All right, let's get into it. And what I'm giving you over here is just, I am, listen, we've said this over again. Like the Karen Reed people, don't come over here. Like, don't come over here. This is for folks that actually just want to listen to my breakdown of the law. I don't want super fans. I have a real job. I'm not relying on YouTube for money. So I get to say exactly what I want to say, and I'm not indebted to anybody. Okay. So we're back with a legal pad, all right? We're back to the legal pad. That's actually why I was a little behind schedule, because I got all comfortable and then I realized that I forgot my legal pad. Let's get the legal pad. We have a lot to get into. All right, hold on. We have timestamps. We're not gonna rewatch everything because I've watched most of the proceedings, not everything though, because I was working and I often had to get up. All right, let's start up here. Okay, there's a lot that I've written on this pad. All right. Okay, I've also taken a few notes just on Lori. There were some things I was just thinking about related to a case, and her case was not even in session, but I was thinking about her. All right, let's see. I just have to make this out because I have a lot written down. All right, so let's start with Hank. All right, they had motions. These folks, these are some stressed out individuals. The prosecution, the defense, these are some stressed out individuals because they started off with motions. They started out with motions, and motions were actually not all the way addressed. Now, from what I recall, I was not taking notes then, but Brennan, the Commonwealth, had filed some motions. What I remember was that one of their motions was tailored towards the defense opening statement. They did not want the defense to talk about third party culprits. And then there were some other motions, but we're not going to get into those.
this case has
All
in the
right.
car and they
I
decide
should have
that
taken
they're gonna go
down.
back 30
I should have taken down the
John,
timestamp. I have some
focus
timestamps.
on his task.
contested, you will determine where the truth lies.
All right.
Ultimately,
And Bev Canoni was sighing. This girl was sighing. I don't know if she's just out of breath, if she's over it, if that's just her nature, but she was sighing. So we have, I don't know, 2 or 3 months of Bev Canoni sighing.
this jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt.
All right.
People outside of this building have rights, and we know that they have voices, but this trial will be decided by you,
Okay.
an independent jury, free from outside interference, based
I just don't know. I mean, I do have faith in the process, but I'm a little, no, I don't know. I'm a little skeptical, but let's just get into it. Let's get into
only
it.
upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, you must ignore it so that the rule of law will be upheld. Which leads me to the fact that it is very important that during this trial, until you deliberate, you must not discuss this case with anyone. This includes your family and friends, and even your fellow jurors. Nor should you allow anyone to communicate with you about any specific aspect or any aspect of this case. You must not conduct any independent research about this case, the matters in this case, and
All right. So, Ali, to answer your question, Lori Vallow faces a life sentence without the possibility of release until serving at least 25 years. I don't even know how old isn't Lori, like in her 50s.
the
So
individuals involved in this case. In other words, you must not consult the internet or do anything else to try and find out information from any source outside the confines in this courtroom. Please be very careful with your social media use. Please do not use X or Twitter, Facebook, Instagram, or Reddit. Though you may never have seen anything about this case before on your social media
Right.
feed, you cannot control
All
what
over.
may pop up. You should also remember that use of these platforms can be public and traceable, and any searches undertaken or information received by you can and likely will be discovered. So please be extremely cautious. If you inadvertently see something about this case, please disregard it and let us know. As best as you recognize them, please have no contact with any of the participants in this trial or anyone associated with either side, including the lawyers.
Bev.
Please do not visit any locations that may be mentioned during the trial. We'll go on a view, as I told you, and I'll discuss that with you before we go. Remember, you were instructed that you must not, and you assured us that you would not read, watch, or listen to any account of any aspect of this case in any news media, social media, or from any other source. It is critical that you follow that instruction. Finally, please continue to keep an open mind. I know that you
Ali, I don't know that I was asking you anything, or maybe I was. I remember the last thing I remember addressing to you is Lori's possible sentence, which is what is this? Possibility. Hold on, she's not facing the death penalty in Arizona, though. I have a whole bunch. I have too many tabs open. She's not. She'd have to serve at least 25 years before she could potentially be released in Arizona.
You will try this case according to the oath that you've just taken as jurors.
All right.
When you took that oath, you promised that you would well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that oath, approach this case with an open mind, and make your decisions fairly and without prejudice or bias or sympathy for anyone, then you will arrive at a true and just verdict, and that's all we ask of you. So it's now time for the opening statements.
Okay.
Mr. Brennan.
All
Thank
right.
you, Your Honor.
He's such a serious man. He is such a serious man. I don't know. Karen Reed, Mrs. Reed just cannot stand looking at the prosecution. They, and here's my thing. No, let's move on. You guys know I can talk. So let's move on. We're trying to get this done.
At 6:04 a.m. on January 29, 2022, the alarm bell sounded in the Canton Fire Department. Firefighter, paramedic.
I liked,
Not all.
we're gonna get into it, but I definitely liked Brennan's opening. Okay. He started off again, he starts off with the firefighters, which is again, I had not anticipated anything. I don't anticipate anything when it comes to these cases because you just don't know what's gonna go on. But he started off in again, him starting off with the firefighters, that was unexpected for me. Again, I had no expectations. I did not know which route he was going to take, but I liked the way he started off.
He knew what that meant. His heart skipped a beat. He raced to his equipment and he picked up his bag, which was meticulous. There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter paramedic, that means that a person's heart has stopped. He didn't know who it was, he didn't know where it was, he took his bag, he had just gotten to the station, and he rushed to the ambulance. He was one of the most senior paramedics that morning.
That haircut is sharp. That's a
Another
sharp
paramedic,
haircut.
Anthony Flamati, would be running
He has a
this mission.
three-piece
Jumped to the
suit
back
on
of
and
the
everything.
ambulance, the door shut, and they headed off to 34th Fairview Road.
Okay.
As they drove, firefighter Nuttall could not see anything. He couldn't hear anything other than the engine of the ambulance. He could feel it sliding across the road. It was near blizzard conditions.
Right.
He calmed himself, he steadied himself. This is what the firefighters and paramedics are trained to do, to focus. And he focused on his task. He looked around the back of the ambulance to make sure all the tools were in place. The ambulance was meticulous as well. This was Anthony Flamati's ambulance, and it was well stocked. He calmed himself, and he thought about what was going to happen. What should he be looking for? What is his next steps? He played the scenarios through his mind, and every calm was above him. As the car pulled up to 34 Fairview, the ambulance, he stood at the back door, the doors open, and he stepped out into Daybell.
This was great. It's good storytelling. And again, I don't know, Benji, had you previously watched not Lori, we're done with Lori. Had you previously watched Karen Reed's trial or not? Because I believe Allie had watched this trial. Right. So I was listening to the opening statement, keeping in mind what I can remember from the initial trial. The reason why I liked Hank Brennan starting off with the firefighter is because that is okay. The reason why I liked him starting off with the firefighter is because that is a neutral witness. Okay, it's definitely not the Canton police. You don't want you don't want to start off with the Canton police because they're very chaotic. They're very problematic for the prosecution. He also does not start off with the defendant, which is that's usually what is typical for the prosecution, right? You're talking about the defendant. We've seen that in the Lori Daybell trial, and that's typically what is common. So I just prefer the angle that he started off. He starts off with a neutral party, somebody that had nothing to gain in this trial. All right, let's listen to him a little bit, but I've pretty much summarized the points that I took away.
He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around him.
And he's a great storyteller. All right, he's a good storyteller. This is typically how I like my opening statements, where you actually have a story, something to tell the jurors, something to grab their attention.
You will hear him tell you how he trudged towards those screams in the darkness to snow. And when he got there, he saw 3 women
Okay.
surrounding a man lying, not moving on the ground. He walked up to the man and he reached down and he tried to find any signs of life, pulse, anything. And he found nothing.
All right.
And he got up and he walked over to the woman and he walked over to that defendant, Karen Reed, and he told her that he thinks that man is gone. And then he heard the yell from Anthony Flamati, the chief, and he said, "Come back, let's go." Because you'll learn that in the cold, even if somebody's heart stops, even if they're presumed to have passed, sometimes you can still save a life.
Okay.
So you'll see on a dash cam video, you'll hear from testimony, he went back to that man, who was John O'Keefe. He went back to him, and that crew, coordinated effort, they did everything they could to save his life. They got on their knees, they began CPR.
This was good opening. This was really good opening. I liked Brandon's opening.
And
I have a few criticisms, but we'll eventually get to those.
Not only will explain, as he kneeled over John O'Keefe, he looked up, and the defendant approached him, and you'll see it on the video. Now, he wanted any information, because when you're trying to save someone, you want to know, are they on drugs, medication, do they have a heart condition? And he looked up at Miss Reed, and he said, "What happened?" And you'll hear her words to firefighter Nuttall. She said, "I hit him, I hit him, I hit him."
That is damning right there. We've talked about this. We're going to get into this statement. We're going to hear about this "I hit him" statement or statements over and over again. All right. But I don't remember which trial we're covering. But there's a specific trial we're covering, and we're going to see, because according to me, okay, my dramatic hyperbole sense, Karen Reed did take the stand today. All right. She definitely took the stand in the prosecution's case today, and we'll get there eventually as testimony progresses. We've talked about this before, where I told you guys that when I was a prosecutor, the first thing whenever I got a police docket, okay, whenever I got a police docket, and during my time as a prosecutor, I handled a whole bunch of cases from like murder to rape to robbery, uh, petty theft, and I don't know all types of. I've even handled. There was something related to a dog, or so. Even as a public defender, I dealt with some dog cases, but I handled all sorts of cases. And the first thing I always did, I went through the docket to see if the defendant made any statements. That's the first thing I looked for. And when I was a public defender, the first thing I did was to see if my client made any statements. So those remarks there are pretty damning. Whether not the prosecution, whether the defense can poke holes into those statements and others, it's it's up to the jury to ultimately determine. But those statements right there are pretty damning, and we're gonna compare those statements to, because it's us watching the opening in real time. I thought about Melody Ferris. If you guys don't remember Melody Ferris, that is the defendant out of Georgia. I don't remember which county. It was not Fulton County. She was married to a prominent attorney. I believe his office was in Atlanta. I believe his office was in Fulton County. In any event, Melody Ferris case, there were a lot of the viewers were divided. Some folks were of the opinion that, okay, there's no way Melody Ferris could have done this, right? And the defense, or at least the evidence to some extent, the defense poked enough holes that pointed the finger at Melody Ferris, one of their sons, okay? But to me, the convincing part in that Melody Ferris trial, it was her statement to her lover that he was in the burn pile. That was literally the statement. He's in the burn pile, or he was in the burn pile, something along those lines. So, and we have to contrast that to Lori Vallow. I mean, I was thinking about Lori because it was jury deliberation. So as far as Lori Vallow, I believe she had a text message something along the lines of, I'm paraphrasing here, but I think it was something along the lines of, we got rid of him, something along those lines. So those words, those I hit him, I hit him, I hit him, those are damning words. Keep that in mind. But let's get into it.
And it was at that time, through the words of the defendant, that she admitted what she had done that night, that she hit John O'Keefe. Now, those words didn't mean anything to firefighter Nuttall. They weren't in context. They didn't reconcile with the injuries. They didn't help him in his treatment, so we ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator. He is not a detective. He's a first responder. And so he takes that information. It was useless to him. He continues to work on John O'Keefe, trying to save his life. You'll see the team put him on a stretcher. And when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard ground, frozen. And beneath his body lays his cell phone. They bring him to the ambulance, and while they're bringing him to the ambulance, you'll see on the videos that other first responders speak to the defendant.
Oh, I was very surprised. I was pleasantly surprised today when the attorneys were introducing themselves to Kanoni, and there was Lolly. Is it Lolly or is it Lally? Whatever his name is. I suppose it makes sense. I was just not expecting him to be in court. It makes sense because he is the previous prosecutor. I'd like to assume that he is, still familiar with the case and can easily get to, different exhibits, transcripts, and things of that nature. So his presence is definitely helpful to Brennan. It's not something that I had, foreseen.
One first responder, for that issue, will say, I hit him, oh my God, I hit him. And then she was interviewed or asked questions for background information, not a criminal investigation, just background to try to help John. And she was asked questions about his background. And during that conversation, you won't see the defendant with a person by the name of Jen McCabe and a firefighter McLaughlin. And she tells Fire McLaughlin, the third first responder, I hit him. They bring Mr. O'Keefe to Good Samaritan Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his core. And unfortunately, firefighter Nuttall's first instinct is accurate.
Okay.
John O'Keefe passed. So why are we here today? We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Karen Reed. You will learn through this case, through facts, science, and data, you will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in that dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out and he stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant in her SUV drove away. She drove at least 35 feet away. The argument was over. It had ended. But then she stopped. She stopped. She put the Lexus into neutral, and she waited. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press, not 25%, not 50%, up to 75% acceleration. There was a light dusting of snow. The Lexus tires spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull, and there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look.
All right. So here's what's a bit of a challenge for the prosecution as far as the jurors are concerned. Okay. The facts of this case are a little different in the sense that oftentimes when, cases are brought for Merck, oftentimes it's, a direct, for the most part, sometimes, direct evidence, right? Even if it's circumstantial, it's not really a case that requires a lot of thinking and a lot of tracing, right? In this case, though, they talk about a vehicle moving forward uh, and then backing up or whatever and then hitting the guy. So that might be a little challenging for some jurors to come to terms with. But that is their theory. That is the prosecution's theory. Uh-oh, hold on. What did I do? Okay.
Mortally wounded. Yet he was. And she simply drove away. Now, before I tell you about the data and the facts and the science, and I walk you through that, I'd like to tell you a little bit.
All right, so that is the prosecution's theme. They're focused on the data, the science, and the facts. All right. So they are pretty much trying to focus on what they think is testimony that cannot be refuted or testimony that cannot be challenged. Outside of the Alberts are problematic. We're going to find out as testimony goes on that those people are problematic. And then Proctor is also really problematic because as I was listening to this in real time, I pretty much made a note to myself saying that Brandon needs to address Proctor. Okay. He needs to address Proctor in his opening. He did not address Proctor. Not one bit. He did not address Proctor. And even as I came home, I was still thinking back and forth. I personally think that he should have addressed Proctor just because it will appear as if the prosecution has nothing to hide. But I suppose Brandon is probably taking the route of focusing on what he thinks he can prove as opposed to focusing on the bad facts. Proctor is a thorn. We've talked about it. We've talked about it at length. Proctor is a thorn. So I suppose he's just trying to ignore that. And I mean, there have been times when I have tried to ignore my bad facts and just because I have no real way of arguing otherwise. But I still think, again, it might be different. Proctor still gets to testify, right? And the prosecution can do something with that. But I would have preferred for Brennan to address Proctor head on. I just think that would have been a better approach.
Bit about John O'Keefe. John O'Keefe was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Henry O'Keefe, John O'Keefe Sr.
Oh no. Okay, so Ali is saying that junior co-counsel did not approve of Lori's famous green chicken. No, it's green something. Oh, green chili. There we go. Lori's famous green chili chicken enchiladas. I don't blame her. I just I don't know. It doesn't seem like something I'd want to eat.
The brother of Vallow.
At least not I mean, we looked up a recipe last night.
Grew up in Canton, worked hard, he became a police officer. But what you're
All
gonna
right, so we're gonna skip forward a little bit. But what I also liked that Brennan did was the fact that he told the jury who John O'Keefe was. Okay, so he focused a little bit more on who the victim in this case was, which was good because oftentimes people do forget that there's a victim in this case. And then, based on this is me paraphrasing, but what it sounded like Brandon was saying is that John O'Keefe and his niece and nephew, they had a good life until Karen Reed arrived. That's what it sounded like to me. Um, and then he again goes on to talk about, you know, the facts, the science, and the data. That he repeated that, basically told the jurors what their theme and the theory of the case is. And then he went on to talk about Karen Reed's campaign of public statements. Because I think I have my timestamp wrong. Oh no, my timestamp is accurate. I have to be focusing on the clock over here. So let's see if we can find, because I looked down here and I'm like, this is 141. But anyways, let's find 1041. Let's see if we can get to 1041. All right, so we're almost there. So this is when he talks about Karen Reed's, you know, publicity. I don't even know if it's a publicity stunt.
How the data from
Okay,
that black box coincides with the cell phone and the movements of the car, the moments before,
okay.
during, and after the defendant's.
Oh yeah, and they had a lot of glitching going on with Law and Crime. I was already into Law and Crime, so I was not
There are
exactly
three
going to
charges
switch.
against the defendant in this case. The first one, second degree murder. When most people hear murder, they instantly think
In about 5-10 minutes, I'm quickly gonna have to get up and parent, but I shall be back, like in, you know, about 5-10 minutes.
shooting somebody, stabbing somebody, playing, you know, a little bit of premeditation. For I will start doing a lot. I'm not going to trample in that area, but I can tell you clearly, we are not going to try to prove that Karen Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted him dead. That's
Okay.
not second degree murder. What we'll prove to you is she engaged in an intentional act, driving back at him at that speed, in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act would cause a plain and strong likelihood of death. That's what will prove second degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused his death.
All right.
The third charge is leaving the scene after knowingly causing death. Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left him behind. And he died. That's the whole group. This case will come down to the science and the data. The science and the data that cell phone is the best of historians. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't
There
suffer.
we go. So he's basically saying that, you know, their science and their data, not a drunk, and, you know, the memory does not fade, unlike the first prosecution's witness.
From emotion, pride, or pride. It is facts. It is data. And that facts and data will lead you to the truth in this case.
All right.
But after Ms. Reed was charged, she began what you'll learn as a campaign.
There we
A
go.
campaign to make public statements. 2020, Nightline, Fox 25, a documentary.
Literally, when Brandon, we talked about this before. All right. We talked about this before. I told you guys that all these things and statements that Karen Reed was giving outside of court, that's fair game. That stuff's gonna come in. And when Brennan talked about, you know, this publicity, or, you know, the campaign that Karen Reed was on, literally when he started saying that, I was like, you stupid motherfuckers. Because the defense always has an easy job. The defense always has an easy job. Your job is to pretty much contradict whatever the prosecution is saying. And under these circumstances, defense gave the prosecution ammunition they did not need. In essence, they had their client on a witness stand incriminating herself when she otherwise would have been protected. So I was really pissed off. You guys know that I was always pissed off about Karen Reed being in public, making these statements. And this is the problem. This is the problem. Now the prosecution's using those statements, and I was really, really upset. Apparently I'm a little invested, but I was really upset about the fact that the defense had, listen, have the sister, have the brother, have the mother, have somebody else in the media talking about this case, but to have the actual defendant in front of cameras talking about a crime that she's charged with and is not exonerated, it made no sense to me. It made no sense from a public defense or even a criminal defense perspective. And I am disappointed that what's his name? Think. Jackson. He used to be a prosecutor. I don't know why again, he's coming out of, no offense to people in California, no offense to attorneys in California, but I guess when you're used to representing high profile celebrity, I don't know that he has represented any celebrities, but they do things differently. It's just, it made no sense. This will only pay off. The only way this can pay off for the defense is if these public statements had a far reach, to the extent that there are folks on the jury right now that could potentially deliberate, or that will in fact deliberate, that already had their minds made up that Karen Reed is not guilty, or that this is a witch hunt. Otherwise, that's just plain stupid. All right, let's move on. That's enough. That's enough.
And we
It's too early for me to be amped up, all right?
had an opportunity to get many of her statements in the footage, and we're going to show much of it to you.
Okay.
And her statements to you will confirm what you already know.
Again, that was just really, it makes no sense. It made no sense. It made no sense why they had her like a media press run for what?
Science and data, what you will already conclude from the facts independent about what she did that night. Her word is confirmed.
Oh, here they go again. All right, co-counsels, let me parent a little bit. I think Allie said something about parenting. I'm just out here ranting. So Allie said, shout out to all the parents who'll be parenting, and big shout out to all the single parents being single parent, doing single parenting things. Okay. A big shout out. Okay. Big shout out. What's up, Brooklyn? I'm going to let this play a little bit. I just need to parent, and then I'll be right back. And then we get started with the defense. All right.
Statements, her admissions to extraordinary intoxications, her admissions to driving the arrest, her admissions to being angry at dawn that night, and as I say, her admissions that she told. Like to play for you clip one. We're going to hit her first with the statements that she made after she was charged.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped them off.
All right, hold on, folks. I'm back. I'm just here for like another 5 minutes, and then, hold on, another 5 minutes, and then I need to get back to parenting. All right, let's go back here, just because, again, I was listening on my phone, so I did not get to actually see this.
We're going to hit her first with the statements that she made after she was charged.
Okay.
I mean, I didn't think I hit him, but could I have clipped him? Could I?
This is so difficult for me to watch, because it's so stupid. This is incredibly stupid. Why do you have your client? It makes no sense. It makes no sense.
tagged him in the knee and incapacitated him. He didn't look mortally wounded as far as I could see. But could I have
That
done
is so stupid. Now that I'm listening to this is so incredibly stupid. This is so stupid. Why would the defense do this? I'm baffled. But here's the thing, though. I am just. This is just. These people are giving me. These people are giving me stress. I might have to switch over to comedy or something because these people are stressing me out. All right, I'm gonna breathe. Let's. It just makes no sense. It makes no. It's very. What? It, I don't know. Let's move on because I'm just baffled.
he didn't look mortally wounded as far as
He didn't look mortally wounded.
I could see. But could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
That makes no sense.
Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data.
I knew he was gonna say that. So their theme is what? Fact, science, data.
Nor speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth. That on January 29, 2022, a very intoxicated defendant was angry and arguing about the relationship with John O'Keefe. And after the fight was over, she left, but she brought the fight back to him in the form of her SUV. She clipped him, he fell backwards, he broke his head,
So
and then this man who helped, a lifetime of help, was left at the corner of that yard, left to die with no help. The facts, the data, and the evidence will bring you to the truth, and the defendant's own words will confirm everything you've already concluded.
That is so. That is incredibly stupid. It makes no sense. Anyways, let's quickly summarize. These people are stressing me out. I was not this stressed out when I was at work, actually working, but to listen to this a second time, they're just incredibly stupid. All right. Okay, so Brandon, again, he starts off with a firefighter, basically neutral party, saying that, they had no dog in the fight. We know that the prosecution's theme of this case is the facts, the science, the data. Apparently, the facts, the science, and data, not intoxicated, no lapse in memory, untouched. Again, what I liked is that he talked about John O'Keefe, which I thought was good. I personally would have preferred had he addressed Proctor. Apparently, he did not see a need. And Brennan's opening was pretty short. Again, that might have been strategic on his part, but I also wondered whether he's not getting ahead of himself. And the reason for that is because it's his burden to prove. Okay? It's his burden to prove. And under those circumstances, as a prosecutor, you have to cross your T's, dot your I's, because you just never know. All right? And then let's see. Again, the public statements, I'm gonna move on from that. It makes no sense to me. All right, let's move on to, let's see, what is Allie saying? Allie's telling our folks to hit that subscribe button, and let's see, hit the subscribe button. I cannot see. I cannot see. Okay, apparently if you don't do that, you're going to need a real lawyer or public defender, something along those lines. All right, so let's see. Allie says that so she could dig herself a deeper hole in the ground. It's not smart for a bunch of high-paid lawyers that aren't doing smart things like allowing her to do this. That was just incredibly stupid to me. It never made sense to me. And even when we first saw it, I was like, that stuff's not looking good. And here they have what appears to be a sharp attorney leading the case now. So it's just, I don't know, that's just the dumbest thing I've ever seen. No, I've seen a lot of dumb things, but it's up there. All right, let's move on to Jackson. As far as ratings, though, initially I was not really going to rate. I was not going to rate today's proceedings because I thought that both attorneys did well. But, in order to keep things interesting, let us grade, Brandon. I want everybody to take part. So, what is your grade? This weekend, though, I'm going to work on an actual meter. Okay, I'll work on an actual meter. Hopefully, I learn how to actually work graphics and we can bring the meter out every once in a while to see where an attorney falls. In this case, let's see. I think we don't want to go too high, all right? So for Brennan, I'll go with an 8.5. I thought his opening was solid. I still do. My criticisms still stand, but otherwise, I thought the opening was good. It was a good roadmap on the good roadmap of the prosecution's case. All right.
All right, thank you, Mr. Jackson.
Could I have just a moment to readjust?
Okay, let's fast forward a little bit. How much time? Okay, we're still somewhat good on time. We have about 50 minutes or so. I just have to see if we can get to the, because I have real timestamps, but most of my timestamps are really, my timestamps refer to the testimony. I'm hoping we can get to those, but I'll try my very best. All right.
Will establish above every.
Yeah, hold on. All right.
The evidence in this case will establish above everything else.
Brooklyn said, what? Brennan was 8.5. Yeah, Brennan was fantastic. That was a good opening. That's a classic. And even as I was listening to Brennan the first time around, there's a distinction. People like me that have spent a significant amount of time in criminal courts and actually have done criminal cases, we know that the typical presentation of an attorney, it is pretty much what we saw in the Lori Vallow Daybell trial. You just have it's just an attorney, just somebody that's, plain, no theatrics, nothing extra. That's typically what you see. And Brennan is a representation of that. And he was good. That was a good opening. Let's see. What did I miss? Okay, Ellie says that I'm going to email you this week. I have some stuff for you for this channel. That's fantastic. Thank you, Ellie. And my email is still the same. It's iwantareallawyer@gmail.com. And then Ellie says Karen Reed has this natural resting bish face at the extreme end of the scale. She looks like she did. I don't know about that, Ellie. We're not gonna say that. Brooklyn says that he had no passion or rhythm. I disagree with that. Brooklyn and I always disagree. But yeah, I think, again, I forgot what I was saying. So I personally prefer attorneys that present like Brennan. I don't like attorneys that present like Joe Takapina. That is not my type of lawyer. But let's get into it. But then again, I've told you guys, my experience is representing ordinary people. So being in these high profile cases and representing celebrities, that's a different ballgame. That's not a business I am entering.
There was no collision with John O'Keefe.
Okay.
There was no collision. There was no collision.
Yeah, that no collision repetition, I did not really like.
John O'Keefe did not die from being hit by a vehicle.
All right.
Period. The facts will show that. The evidence will show that.
And then again, just a reminder, on this channel, we focus primarily on the prosecution because they bear the burden. And then I also don't have enough time to rewatch everything from scratch. Otherwise, I'll be here and not parenting.
The data will show that. The science will show that. And the experts will tell you that.
Okay.
You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts
Okay.
and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up
Here we
sitting in
go.
that chair on trial for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation.
All right.
A text message of a now fired Massachusetts State Police
There
officer
we go.
named Michael Proctor. He was the lead investigator.
Listen, Alan Jackson and them, they listened to me. All right. They listened to me. While we were going over the previous or the first trial, I pretty much said the defense have to make Michael Proctor the center of their case. I don't care about all those third-party culprit things or their theories because it doesn't make sense. But Michael Proctor does not go away. That's who, listen, you start with Michael Proctor in the opening. Through the witnesses, you talk about Michael Proctor. Through cross-examination, you talk about Michael Proctor. When you close, you finish off with Michael Proctor. You make Michael Proctor the center of anything and everything that has to do with this Karen Reed trial. They listened.
On this case.
You know, these TV folks don't always listen to me, but I mean, Lori definitely did not listen to me. But
And he was talking about a fellow officer, a fellow cop who owned the property where John O'Keefe's body was found. Text message with a buddy. Question.
So Allie says that Brandon, or she found that Brandon was monotone, but he was short and to the point of what he wanted to get across to the jury. With, let me put this on here. So with Brandon doing his opening the way he did, short and to the point, he kept the jury with him instead of losing them in a bunch of other talking points. Yeah, I see that point too, Allie. I mean, again, I do understand why his opening was that short, right? But again, it's your burden. You want to cross your T's and dot your I's. I'm not saying give us a repeat of Love and Abate and everybody else. It's still your burden. So you kind of, I guess you have to, or he has to weigh his interests.
Is the homeowner going to catch any shit?
So, Allie, what are you rating? What are you giving Brandon?
Answer. Nope. He's a Boston cop too.
I like this part. Yeah.
That quote defines the lack of integrity.
Yeah, I definitely like the focus on Proctor. That was, again, they took pointers. Proctor does not go away.
Entire case, its entire investigation, and this prosecution.
Right.
During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic and tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking.
All right, parenting, I'll be right back.
You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. They won't be able to excuse their way out of it. And they can't meet their extreme burden of proof, which the court will tell you is beyond any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m.
Okay.
on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on.
All right, let's quickly fast forward because we only have about 39 minutes. Let us get to the first witness if we can find him. This was a long opening. Let us get to. Okay, hold on. Ooh. All right.
All right, Mr. Brennan, your first witness, please.
Thank you, Your Honor. The Commonwealth calls Timothy Nuttall.
All right.
Watch your step.
And stand and face the clerk.
Raise your right hand. You solemnly swear the evidence given to the court and jury in the case now and herein to be the truth, the whole truth, and nothing but the truth, so help you God.
Sir.
Thank you. You can take a seat.
Sir, could you pull the microphone down a little bit closer to you, please?
Yes, sir. Or yes, ma'am.
If they
All right,
what?
when you're ready, Mr. Brennan.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury?
So my name is Timothy Nuttall. I'm 28 years old. I've been a firefighter paramedic for ever since I graduated high school. I graduated in 2015. I took my
Initially, I thought he was doing a whole lot of talking. You guys know,
EMTs.
I don't like people that just do a whole lot of talking. Wait for specific questions.
Class and got my certification while I was actually still in high school. From there, I moved on to the BLS transfer side of EMS. There's 911 EMS, and then there's transfer, which is basically back and forth from hospital to hospital. I was brand new and
Yeah, and I see on my notes here, as this witness was testifying, as Timothy was testifying, I pretty much made a note for myself that this is a difficult prosecution case. Yes, they have, again, it's Michael Proctor, definitely Michael Proctor, but they have some real problems with this case. And then Allie has a response. Allie says that she would give Brennan a 8.5 as well. She thinks that he delivered his opening well in the sense of not getting ahead of himself and not rambling on and losing people in his opening. All right, Allie. We have Benji. What's your vote? And Brooklyn, what is your vote?
very young.
Right.
So I started on the transfer side, kind of learning the job.
All right, so let's quickly sum this up because I really want to get into cross. We know cross, that's our bread and butter. We want to get into cross examination, okay? And we're limited on time. So as far as Timothy's testimony is concerned, right off the bat, when he started talking, I was of the opinion that he presented as a confident witness. Apart from that, we understand that, he got into EMS or firefighting or whatever it is that he does as a teenager. I thought that was actually really, not to say intriguing, but I was interested in that. I was like, oh, there's a possible career for somebody, right? Like you're watching this and you can go do something else with your life if you want to, right? In any event, so Benji doesn't know. All right, Benji, no pressure. So as far as my first impressions of Timothy, it was obvious that he was well prepped, okay? For direct testimony, he was definitely well prepped. He knew what his role is as a witness, all right? And then he talked about, visibility, about how dark it was, how cold it was. And the reason why I marked down visibility is because this is going to be a recurring theme in this case. As far as visibility, it's also going to come in when the plow driver testifies, right? What we got from Timothy's testimony is that it was dark. Stop. It was dark. and cold, and it could potentially explain the plow truck driver missing or not seeing a body at all. And this theme was repeated when Carrie Roberts testified, but we'll get into her in a little bit. Okay. The most significant part from his direct was 1221. Let's get to 12. Where's 1221? Okay, that's 1208. No, is it 21 or 12? Yeah, 1221. Let's get to 1221. No, it's too far. I went too far. All right, let's just go back a little bit. All right, let's do this.
Looked up and saw.
In between Mr. Jackson and or next to Mr.
And
Jackson.
that's what I thought was so. This is the in-court identification. Let's just back up a little bit.
This person,
The person that you looked up and saw that was standing over you with blood on her face, do you recognize that person in this courtroom?
yes, sir.
With the court's permission, sir, could you point out that person that you looked up and saw?
In between Mr. Jackson and or next to Mr. Jackson.
I see. So when you looked up and saw that person,
That's what I thought was a bit different about Brennan's style. You guys have watched enough trials to know that oftentimes when there's an in-court identification, the attorney asks for, the record to reflect that, XYZ has identified the defendant. Brennan did not do this for this witness. He also did not do this for Carrie Roberts. And I thought that was pretty odd, or maybe that's just, again, that might be how he does it. But I thought that was a little odd.
and asked about any background, what did she say to you?
I hit him.
Okay, so that's the most significant part. That is, the admission, confession from Karen Reed, if you will. All right, that's damning. That's damning.
How clearly do you remember her words saying to you, I hit him, I hit him, I hit him?
I remember it very distinctly.
Okay.
You've been to a lot of calls over the years and since.
Yes, sir.
All right, so we're gonna skip over to cross. So cross, we're gonna start with 1242. I think that's when it starts. 1242. Is that it? Okay, let's go back a little bit.
Several times, correct?
Let's go back just a little.
One female, 3 weeks.
The last 3 months.
Yeah, and again, Timothy was definitely well prepped. From Cross, he testified to him meeting with the prosecution team on at least 3 separate occasions. We've talked about this on numerous occasions where I've told you guys that I prep my people. I don't play those games. I don't leave it to chance. I prep my people. I prep my clients. I prep my witnesses. I prep everybody for everything. All right. And my sister will tell you guys that I'm the most prepared individual she has ever met. Usually, because every once in a while, something slips through, and she's like, "That's so surprising," because you're usually, cross your T's and dot your I's. I'm that person. I look up consequences. I read terms and conditions. That's just me. I prep people for life. But so again, the fact that he was prepped, that is not problematic. What defense was trying to elicit, they were pretty much trying to say that Brennan told him what to say. We're not going to go over all the redirect, but we found out that that's not it. Because literally when it was being crossed, here's something. Again, it depends on how much experience attorneys have. But when you prep your witnesses, you tell them to tell the truth. Literally, that's what you tell them. And it did come out during redirect. But let's quickly see 1242. 1242, let's play.
Last 3 days.
Within the last 3 weeks, I believe one the week after that, and then one last night.
One
last night.
last night. What you did discuss, let's take a minute.
I think that's just the beginning of cross. I did not write down the timestamp because I wanted to get to the part where um, Jackson was asking him about whether he heard, he being Timothy, whether Timothy heard Karen say that he hit him, that she hit him 2 or 3 times. And to me, that's kind of like, flagging a dead horse or donkey, whatever your preference is, because they're arguing whether she said it 2 or 3 times. Whether it's 2 or 3 times or once, that does not help your client. The only way that helps your client is, as far as his memory, his inability to correctly and accurately recall events as they were occurring. So I have a 12:53 timestamp, which pretty much highlights the difference between the previous prosecutor and this current prosecutor, in this case, the Brennan. So it's 12:53. I'll do a better job with my timestamps tomorrow because today I just I don't know. Yeah,
Did you see it before your grand jury testimony?
No, sir.
Okay, so this is the first time that you've seen it.
Yes, sir.
And you were able to establish for Mr. Brennan exactly when it was that you believe you heard the statement based on your view about 2 weeks ago of that video.
No, that was the way that I remember it.
Right, that's not a trick question. My question is much more simple. You were able to establish after 3.5 years now, exactly where you were and where Miss Reed was and who else was around at the time that you believe you heard those 3 statements in order. I hit him, I hit him, I hit him.
Yes, sir.
Okay.
Is this it? 12:53.
You testified last year as well that there is a normal protocol.
All right, so this is it. This is the distinction between Lolly and Brennan.
Call for removing clothing from a patient. And it's essential to just discard it and get it away from the patient so that you can concentrate on the life-saving measures that you're undertaking, correct?
Yes, sir.
That could be done in the ambulance, it could be done in the hospital, it could be done in situ out there in the field, correct?
Yes, sir.
But the point is you want to get as much clothing off of the person as possible so that you can assess that person's physiology.
Yes, sir.
There's not really a lot of care taken to preserve the clothing from an evidentiary standpoint in your view, correct?
And we're trained to try and, just to take example of a shooting, try not to cut through the entrance wound of the clothing.
Fair enough. I mean, when you're literally trying to save someone's life, your job is to get the clothing off and get it out of the way.
Yes, sir.
You're not sticking it in an evidence bag and sealing the evidence bag, things of that nature.
No, sir.
So it might end up on the ground.
Yes.
Right? Might end up with some debris on it.
Yep.
Might end up on the floor of the ambulance.
Yes, sir.
Oh, and I think I forgot to grade Jackson's opening. I'd give it an 8.5 as well. I'll give it an 8.5. Again, 9 is reserved for something really out of this world. We've not seen it yet.
Could end up in the floor of the hospital or on the floor of the hospital. Is that right?
Yes, sir.
Okay. And if it's tossed in the floor of the ambulance, the clothing may well pick up debris from the.
My time stamp is off, but I believe what I was trying to highlight here is he was asked a question along the lines of what his preparations at the previous trial consisted of. And he pretty much said that there was no preparation. So that is the biggest distinction between Lolly and Brennan. And probably that distinction is going to become apparent as the trial actually goes on.
The ambulance.
Oh, yeah. Yes, sir.
Or the debris from the floor of the hospital or wherever.
Mm-hmm.
Is that yes?
Yes, sir.
Okay. You testified previously at the grand jury in April of 2022, correct?
Yes, sir.
I have 25 minutes, so hold on. Let's recap. So there was this whole discussion on cross-examination. Again, he was testing Timothy's memory because Timothy claims this is the one troubling aspect of Timothy's testimony. Timothy claims that his recollection is better with time. So apparently, as the days go on, he has better recollection or memory of this incident, right? Or at least him responding to the scene, which was really puzzling. And what Jackson did that was actually really brilliant is the fact that he did not let up. All right, pretty much every time that he contradicted himself or he mentioned something that did not line up, he pretty much remind this witness that I thought you said that your memory gets better with time, and that obviously proves that memory fades over time. So there was this whole testimony or cross-examination about him testifying to John O'Keefe having a coat on, or at least being dressed appropriately for a blizzard at the time. And that highlights the missteps by the previous prosecutor, because the previous prosecutor did not prepare, he did not prepare the witnesses. And because he did not prepare the witnesses pretty much were relying on their own memories, which is, there's no person. I have a really good memory. And even I did not know that I hope I'm not called to testify ever. But if I'm called to testify ever, I highly doubt that I would be able to point out every single thing from memory without having enough time or gathering enough time to pretty much get my get my ducks in a row. But yeah, the previous prosecutor, I don't know what he was doing, but he did not prepare his witnesses. Let's go to 102 quickly. 102. Let's just play.
You had a, quote, much better picture of what we were dealing with, correct?
Yes.
You noticed once in the back of the ambulance that he had trauma to the right side of his head.
Correct.
And as a matter of fact, when you were pointing at it, I'm doing that on purpose because you pointed to the right side of your sort of forehead above your right eyebrow, correct?
Yes, sir.
Okay. The majority or the worst injury that Mr. O'Keefe suffered was actually to the back of his head, which you noted was quite matted with blood, correct?
Yes, sir.
Oh, listen, we have some more stuff coming out of Fox, people. Shannon Sharp is being sued. He's being sued. The allegations are disturbing. They're serious. And today I just read, because you guys know I'm the open tabs queen. When I was at work, I had opened up a tab and I got to read it when I got home. And the tab was something along, or at least the article was something along the lines of, there was mediation and Shannon Sharp had offered the plaintiff $10 million. I was like, what the hell? Anyways, we'll get into that. Not right now. Not right now. We need to stick to.
I want to talk about the injury to the right side of his head as distinct from the back of the head injury for just a second. Before I get to that in detail, let me ask you, because I just sort of want to cover the bases. You noted the back of the head injury, correct? Is that yes?
Yes, sir.
You also noted the front right side of the head above the right eye, correct?
We did.
You noted some injury to his eyes. They looked blackened.
Yes, sir.
But primarily the right eye was blackened.
Yep.
And there was a golf ball size egg, I think you put it, over his right eye, often called a hematoma.
Correct.
And you also noted when you got his shirt off that he had scratches along the right side of his arm. Is that right?
Sir.
You indicated on direct examination today that you believe those scratches ended where? Meaning from top to bottom? And I'm not using anatomically correct language. So from shoulder to wrist, where were the scratches that you noted?
There were several. As I noted, they were on his right humerus area.
Tell me what a humerus is.
The right arm.
Biceps.
Right about here.
Okay.
No, a little further, like between where your bicep and your tricep kind of meet. Right about in there.
Okay. And what did the scratches look like?
They were deep. Infamously referred to them as furrows. but they were quite deep. You could tell that there had been some material removed.
Okay. Material meaning skin and flesh.
Yes, sir.
Okay. Some biological material.
Mm-hmm.
Is that yes?
Yes, sir.
And were they parallel? Meaning they were going in the same direction?
Yes.
Were there any scratches below the elbow?
There were. Yes, there were. They were not as significant as the ones on the upper arm, but they were noted.
Okay. And those were parallel as well?
Yes, sir.
And they looked like scratches to you. That's how you described them?
They did.
Last year, when you described those scratches, you curled your fingers up, exposing sort of the nails, and drew it across your biceps. Is that what you were using to describe what the sort of scratches looked like?
I just kind of used that as a landmark, to be honest with you,
Okay.
sir. It was just kind of how I quantified it in my mind.
Okay. But what you did was you did this motion.
Yes, sir.
As you said, there were furrows. And remember, there was an embarrassing moment for me.
Both of us, sir.
I couldn't understand the word furrow because of the accent.
I don't know. Jackson has, I don't know. There are some problematic stuff here, but I'm quickly going to let this play. Let me go grab I'm going to go grab a book quickly. Hold on. I'm going to grab my forensic medicine book.
Right?
Yes, sir.
All right. Let's talk a little bit about the hematoma above the right eye for a second. That's basically damage to subdural blood vessels that causes acute swelling, right?
Correct.
And a very common cause of a hematoma over one's eye could be being hit or punched in the face. We talked about that.
There could be several causes for hematoma, such as that.
Obviously. I mean, it could be a golf club, a baseball bat, or it could be a fist.
It could be.
Okay. We talked about that last year. I asked you if the injuries that you saw on Mr. O'Keefe's face, including the laceration over his right eye, was consistent or inconsistent with a physical altercation, and you said it was consistent with a physical altercation as well.
To the
Excuse me?
objection to referring to past testimony before a question is asked.
So sustained.
Hold on. Did I miss? No, I did not miss the part.
Sure. Do you remember a laceration, in addition to the hematoma, about a 0.8 centimeter laceration over his right eye?
I do.
Tell me I'm using a word that maybe not everybody understands. I didn't understand it when we first started this thing. What's a laceration?
Yeah, that part actually, it. So that part, the part about Jackson not knowing what a laceration is, I found that really, really disturbing. Okay. I found that disturbing for an attorney of his caliber to not know what a laceration is. Because, again, we've talked about, I think this was around the, when we dealt with a YSL trial. I told you guys, when it comes to there's certain things attorneys have to know as far as medical terms and forensic medicine is concerned when you're dealing with the human body. It just, to me, that I don't know. Again, they're the same people that have their client out there giving these press runs and personal statements. So I suppose, but I was just actually really, I was, what, you are a lawyer, have been a lawyer for at least close to 30 years. You've dealt with, I assume, assaults, aggravated battery, even murks and other types of, crimes against a person, and you do not know what a laceration is. Anyways, hold on. I'm going through my forensic medicine book here. Let me go through it. That's what I should have done instead of, being on the internet. That's what I should have been doing, prepping for this. But let me get to the right page and then I'll be back.
What's the difference between that and a cut?
A laceration is they're basically the same thing. Laceration is just a deep cut.
Okay. So it's a parting of the skin.
Correct.
In other words, where the skin separates.
Yes.
And that can be from blunt force trauma, meaning something hits it rather than cuts it.
You can get
Sustained.
What are some of the causes of lacerations?
a laceration, as you noted, blunt force, but you can also get a laceration from a slashing movement, from a stabbing. I mean, that is still a laceration.
What about a hematoma?
That is primarily caused by blunt force trauma.
Right. And the hematoma and the laceration were right next to each other, correct?
Yes, sir.
Okay. And you indicated last year, or let me ask you this way. Is that consistent or inconsistent with a physical altercation?
Objection.
I'm sorry, folks.
Can you answer that?
Chaotic.
I could not say, Your Honor.
Okay,
Chaotic
next
over
question.
here. I'm
Well, last
hearing
year, you indicate you can't answer that. Last year,
Chaotic.
you did answer it, didn't you?
Objection.
So I need to see Councilor Sidebar for just a minute, please.
And during me skipping a lot of the testimony and the footage, you guys obviously did not get to hear what's her name again, Bev Canoni huffing and puffing, but she was huffing and puffing a lot during the prosecution's opening. I did not hear a lot of that during defense, but she was huffing and puffing. All right, let's fast forward. Let me see. Benji said, this girl I'm talking to that's interested in me is telling me that she works in a court trial and his client, I think she's a lawyer. Any advice? So Benji wants advice for dating a lawyer. All right. So I'm going to have to ask one question before I can give you some advice that's not legal advice. Does this woman have children or not? Okay, that does make a difference. And how long has she been in her current position? And then we'll move on to the next part. All right. And then Benji says Shannon Sharp allegations. Is there anything real there? We were talking about this. My man and I were talking about this. And here's the thing. Because when was it? Was it yesterday? I believe today is what? Is today Tuesday? Yeah, today's Tuesday. Yesterday, that's when, all the headlines were making rounds, right? I did not really look much into it because I just did not. Okay. But today, based on the article that I read, apparently Shannon Sharp's attorney, these are allegations, all right, Shannon Sharp, I don't have money on here, all right? So it was Lanny Davis, if I'm not mistaken. My daughter took my phone. I believe the defense attorney's name is Lanny Davis. And according to Lanny Davis, they had a conference. So it sounds like Shannon Sharp actually knew that this was coming because they had a mediation. So what a mediation is very different. It's different from, say, we're going to go back again. I like to refer to cases that we've actually watch together, just so that folks, I'm hoping that you get a better understanding and it's not confusing, because my goal is not to make things more confusing than they should be. But if we go back to it's not the YSL trial, a case out of California. If we go back to the why did I say ASAP Rocky? If we go back to the ASAP Rocky trial, in that case, there were some, questions about ASAP Pirelli asking for payment. And I believe even, what's his name? What's the guy's name? I can see him now. The one that they flew up from Paris, from Paris business class. Sajimi, I believe that was his name, Sajimi or something along those lines. So if we go back to those text messages between Sajimi and Relly, Sajimi was like, oh, why do you have to involve the boys? You can just, ask for some money or whatever, and this thing will go away, right? And pretty much Relly was talking about how that would amount to extortion. He's like, if you ask for money without a lawyer, that's extortion, all right? The distinction here, and if Lenny Davis does in fact represent Shannon Sharp, and if he did in fact say that Shannon Sharp offered this claimant $10 million at a mediation, then there might be some truth to those allegations. And the reason why I think there might be some truth to it, again, mediation, that is an out of court process. Okay, it's almost similar to going to Judge Judy, but not really Judge Judy, because Judge Judy is arbitration, but it's similar to that, where you have attorneys for both sides, and then you have a mediator who's a neutral party. Oftentimes it's another lawyer. Okay, and during those proceedings, this mediator is going back and forth between the two parties, trying to come to a resolution, okay, trying to reach an agreement, trying to reach a type of settlement. And that's something that I do day in and day out in my current position, because for workers' compensation cases, that would depend on the state. But a lot of states do have mandatory mediation. So before you file a lawsuit, you are required to pretty much take the case to mediation, and only if the case does not settle, then do you go then do you file the lawsuit. That's the way that it is in a lot of civil matters in the jurisdiction that I currently reside in. Okay, so under those circumstances, to have an attorney be represented by an attorney, be at the table, and you have an offer of $10 million for allegations, there might be some truth to that. But as again, my man and I were talking about this, here's the thing. Because I'm trying to figure out, mediation is secret. That's confidential information. We don't typically, folks are not privy to that information, but it would make sense for, if this Lanny Davis person does in fact represent Shannon Sharp, it would make sense for him to disclose that information to the court, because he would otherwise be pretty much signaling to the court that, hey, we've tried mediation, things fell through, or things did not work out, and that's why we're here. $10 million is a significant amount of money. That's a lot of money. And again, the reason why I brought up the ASAP Rocky trial is to show the distinction. Mediation is not, rally texting Rocky and other people asking for money. That's not it. Mediation, you pretty much have a lawyer. The allegations have been floating around for a significant amount of time. A demand has been sent out to the defense attorney. And if what this lawyer is saying is accurate, Shannon Sharp already knew that this was coming. And you guys know I can talk. But here's my thing. Whether these allegations are true or whether these allegations are false, Shannon Sharp failed to protect himself. All right. This was my sense when I was talking to my man. I'm like, he failed to protect himself. And the reason the reason why I'm saying that he failed to protect himself is because he is a walking commodity. He is a walking cash cow. All right. And under those circumstances, he can, go on and talk about how he does not want commitment. He does not want women leaving toothbrushes at his home. He does not want X, Y, and Z. He can talk about all of that. And he can talk about how he's into younger women. I think that's really gross. That's really gross. That's disturbing, whether it's men, women. I don't care. I don't like huge age gaps. From my perspective, I think that a man that grown, if he was actually worth any substance, women his age would be interested in him. Or maybe they are, but he's just into little kids. To me, by little kids, I mean young. There's no way, to me, it makes no sense for somebody in their late 40s or early 50s to be dating a teenager. What the hell? What gratification are you getting from a teenager? I'm sorry. To me, that's disgusting. That's absolutely. What are you talking about? She might be talking about TikTok. I don't know. Maybe I'm just old school. Maybe I'm just overly conservative. I cannot relate to that. I don't know. You're dating somebody, sleeping with somebody that's within your daughter's age range. That's weird to me. And in any event, I just lost my train of thought. I'm supposed to be looking for something in this forensic medicine book. But overall, I do not know that you offer somebody that amount of money without there being, there has to be something there. But again, we're going back to Shannon Sharp. What could be advantageous? That's the thing. More that's one thing about me. I have fours, I have cons and pros. I basically look at things from both sides. I don't agree with his dating lifestyle, but that has nothing to do with me. But one thing you guys will learn about me, even under circumstance, I try not to be biased. Okay, I try not to be biased. I try to check my biases. So this is going to sound weird just for somebody that was ranting about age difference and X, Y, and Z. But what could be advantageous for Shannon Sharp should this proceed? Should this actually proceed to trial? Is that in the event of a jury verdict, a jury could pretty much award $1 million, which is less than $10 million, which is what it offered, and definitely less than $50 million. So it could work either way. And from, I guess, a non-legal perspective, my man thinks that if their allegations of are then it would make sense for this to actually be a criminal case. But again, we're not going to get into that because it can be either way. I've talked about it when it came to Raleigh. It just depends on how the victim or the alleged victim wants to proceed. Some people have no interest in pursuing criminal charges. Other people do. And if I heard correctly, because I listened to the Breakfast Club a little bit this evening, and I believe that I heard Lauren LaRosa say that the victim or the alleged victim in this case, or the plaintiff in this case, is being represented by attorney Busby. That's just, listen, he's problematic. That's a problematic lawyer. But okay, let's move on because I've been doing a whole lot of talking. Okay, so she doesn't have kids. She's age 25. All right. The reason why I was asking that is just because typically for people with children, you have to understand that those kids are going to be first. All right. That's typically just how it happens. And if you're comfortable with that arrangement, then, that could work. All right, let's see. Benji said, and I just found out today, but I'm definitely curious to find out more about her job. Okay, what kind of law does she practice? Do you know? Okay, and then Benji says the Shannon Sharp situation. That stuff sounds awful. The 10 million, again, I'm just saying this from the mediations that I have been in, okay? When you're offering money, when a defendant is offering money, there's a lot at stake and they're trying to get rid of the case. All right. And yeah, the Shannon Sharp, I'll take a deeper dive into this. Hopefully we'll see this weekend. I'm trying to do some family stuff. But eventually it might be in 2030. I'll have a video out on, oh my goodness, Alexa. Sorry, I forgot to disconnect my Alexa. Okay. So Benji says that he has dated a woman with kids for a bit and it didn't work out. Why didn't it work out? All right. So let's get into this. Let me find the next timestamp while I look for, hold on. This is, all right. So we talked about that. And then my note was basically like, how does the fence not know what a laceration is? Okay, 204. Let's go to 204. Let's go to 204.
What is the strength of the defense's case?
Oh, that was some great, huh?
I'm going to go with Taryn. I apologize if I mispronounce it. Taryn.
What was 204?
And this is important.
He was the only person taking.
She didn't left in a particular ambulance, correct?
Yes, she ended up driving ambulance 1 to Good Samaritan.
And
hold on, 204. No bueno.
Well, like you saw. Can I ask you, after you cleared the hospital and got back to observation, firefighter McLaughlin, any of them,
Hold on, folks. I'm just trying to find that
They're-
timestamp. Let's see.
remember, correct?
Well, like I said, it's mostly those debriefs are usually they're very
I don't know. They had problems. Law and crime had serious problems. Real problems.
Equipment, make sure that the ambulance is ready for the next call, etc. I'm asking about a general debrief with the fellow firefighters, male and female, that you were with at that scene. You're telling me that you don't remember debriefing and discussing the incident and your observations at the incident following that incident.
No, sir.
Okay, but
I'm
your memory,
behind
you indicated
schedule.
earlier, gets better with time, right?
Yes, sir.
And then again, that not the prosecutor, the defense definitely locked in with that, his testimony that his memory gets better with time. They did not let up, not one bit.
You don't remember it as you sit here today?
Not one bit.
Ask the question again.
Sure. Do you remember discussing with firefighter
Close the door.
Flamati, firefighter Walsh, firefighter Kelly, firefighter McLaughlin, any of them, your observations and what happened while at the scene after you cleared the hospital and got back to the station?
No, sir.
Have no memory of that whatsoever.
No, sir.
When we left off before lunch, I was asking you about a hematoma and a laceration over the right eye of Mr. O'Keefe. Do you recall that?
Yes, sir.
I asked you, being punched in the face, can that lead to a small laceration like you saw and a hematoma like you saw?
Objection.
I'm going to allow it.
Uh,
You answer that question.
I couldn't speak to how that injury occurred.
Is it consistent? Are those injuries, just those injuries, are those consistent with being punched in the face?
Those injuries could be sustained from numerous ways.
And
yes, it could be from that. It could be from others as well.
Okay, so that's what I'm asking. It could be. In other words, it's consistent
Yes,
with
sir.
being punched in the face, correct? Correct. Thank you. I want to ask you about this statement that you indicate that you heard that now is 3 statements, 3 phrases, correct?
Yes, sir.
When you heard this statement, describe for me exactly where you were. What were you doing and who was around you?
I was knelt at the head of John O'Keefe with a bag valve mask, delivering ventilations. Firefighter Kelly was to the right, and firefighter Flamati was on the left side of Mr. O'Keefe, and the 3 of us together were working to perform CPR and ventilations.
And your job, and I hate to butcher it, but you'll correct me.
Yes, sir.
Your job was to do the airway, correct?
Yes, sir.
And I'm picturing a big balloon-like apparatus that you put over the patient's mouth. And
Exactly.
squeeze it.
Yes.
That's as opposed to, it's an advancement on just mouth-to-mouth resuscitation, correct?
Correct. Yeah.
You were the airway person doing the squeezing of the bag.
Correct.
What was Tony Flamati, firefighter Flamati,
All right, I
doing?
finally
He
found it.
was starting CPR.
Jeez, it took me forever. It took me forever, but I finally got to it. Okay, so this is pretty much under, again, this is forensic medicine. So it's under, hold on, I don't know where you guys would actually be looking up this stuff. But again, so forensic medicine includes every aspect of medical practice, and then which can assist the courts in resolving an issue. All right, so that's the definition. Forensic medicine includes every aspect of medical practice which can assist the courts in resolving an issue. So that's why I am baffled that a practicing attorney, at least one that has dealt with crimes against a person, does not know what a laceration is. So this is under general traumatology. All right. These are basically just basic concepts regarding trauma to the skin. And again, it's important. They basically talk about the importance of it here. So it distinguishes between different types of trauma. All right. And part of those, so we're going to talk about classifications in a little bit. So there are different types of classifications of what they call mechanical trauma. All right. So mechanical trauma or violence can be applied over a large surface area, blunt trauma or violence, or it can be applied over a smaller area, as is seen with sharp violence or trauma. And then there are two main groups. I'm not going to bore you guys with the details, but as you just talk about blunt trauma, you distinguish between contusions or bruises, you talk about abrasions, and then you talk about lacerations. So lacerations, that's the most significant time of blunt trauma that you can find. And to me, it just boggles my mind. I don't know. It boggles my mind. And then again, when you talk about lacerations, they distinguish between lacerated wounds and incised wounds. That's how you can tell the difference between, how, or potentially tell how a wound or an injury occurred, as opposed to an incision from a medical procedure such as an autopsy, things of that nature. But I'm going to get off my high horse right now. Let's see what Benji is saying. Okay, so Benji said she was fine enabling the weird behavior from a sister, a husband, and a best friend. Oh, fiance. Okay. I don't know. I need more information, Benji. I need more information. But let's quickly get into, because I'm way behind. I'm way behind my schedule. Let's quickly go to 228. I really wanted to get to what's her name? Carrie. I wanted to get to Carrie Roberts. I do not know that we get to do that.
And which
But let's get to 228. Let's get to 228. And I'll give you my advice in a moment, Benji. But let's get to 228. No, that's too far. That is too far. Go back just a little bit. I was actually really excited listening to this. I'm like, oh, finally we get a real trial, not the stuff we saw from Lori. She has me baffled. She went through all of that to concede at the very end.
Fighter, not all.
What?
Firefighter, not all.
And overall, to sum up, Cross, I thought Cross was well done. Cross was brilliant. It was not devastating to say, but I thought Cross was really good. I thought Jackson did a good job.
The video the defense just showed you, did you notice any differences between that video and when I showed it to you, and that it doesn't have the time on it?
Yes, those were two different time frames on that video.
And when we spoke about when the defendant said to you, I hit him, that wasn't shown to you in that video just now, was it?
No, it was not.
So if we go back, will you be able to explain where you came from and firefighter Flamati came from, and when you first went over to John O'Keefe?
Sure.
But the court.
I thought that was good redirect from
Ms. Gilman,
Brandon.
if you could start that video.
Yeah, I thought, and even during cross-examination, to me, again, I was just listening, but it was very obvious that Jackson was not showing him the same video. Let's quickly go to 235. 235, hold on. Okay, a little there. All right.
You had mentioned that you had some difficulty about clothing. Do you remember what you had previously said?
I remember there was some difficulty of getting the individual's fingers through clothing just because they were so cold. They were difficult to manipulate. Just they really was not conducive to getting clothing off easily.
Okay. You met with me 3 times?
Yes, sir.
I had not met you before any of your prior testimonies, had I?
No, sir.
Do you remember meeting with me and discussing this case with me?
I do.
Do you remember me asking you to tell me what you remember?
I do.
Do you remember what I told you about testimony when you come into court?
Yes, sir.
What would I tell you?
I remember we discussed that
Maybe something
just
else.
tell the truth.
Did I tell you that it doesn't matter? There is no side. Doesn't matter if it helps or hurts, that you just tell the truth?
Sustain.
Did I ever suggest to you that you should stick to a story?
No, sir.
Did I ever suggest
Again, so I thought this was a good redirect. Thought
to you
this
you
was a good
should
redirect.
offer your testimony in any certain way?
No, sir.
When I talked to you, did I ever ask you to say anything about your testimony to this jury?
No, sir.
Other than what?
Speak to the jury.
Did I need to tell you to tell the truth?
No, sir.
And in telling the truth, did the defendant say to you, I hit him, I hit him?
I'll allow it.
Yes, sir. 3 times.
Again, that is so problematic. But we're gonna move on. I thought cross-examination was really good. I thought redirect by Brendan was really good. And I liked how both attorneys, again, I think that's why I was excited about this. What are you doing? I thought that's why I was excited about this trial. The fact that both sides, for the most part, appear to actually know the rules of recross and redirect. It's a funnel. You just narrow down until there's nothing else to bring up. So that was well done. Let's quickly move on to, before we even get to Carrie, let's get to Karen Reed taking the stand. Let us get to Karen Reed taking the stand. Let's just fast forward a little bit. These are some stressed out individuals. I'm telling you guys now. They look like they have not been sleeping for days.
Defendant came over to you and spoke and then left.
Oh,
Do you
they-
remember hearing?
I started, correct?
CPR was started.
On the waterfall, like what I just
Let's go back. So far,
Let's
Karen Reed,
please.
we saw Karen Reed basically help the prosecution with their opening statement. We see Karen Reed take the second. This is, in my notes, this is witness number 2, okay? Witness number 2 is Karen Reed.
Okay, thank you.
We'd like to play this first and then call Ms.
Oh, okay, I'm
Roberts.
sorry.
Thank you, Your Honor.
Yeah, and in my notes, when I realized that this was happening, this was a mouth drop moment for me. I just could not believe it. I could not pick up my jaw from the floor because, again, I do not understand. I definitely do not understand why these individuals, again, I get it because they're trying to taint, pollute the jury pool, but at what cost? At what cost? This has to be one of the dumbest moves I've ever seen. Whether she is acquitted, convicted, there's another hung jury. This was just plain stupid. Literally, in my notes, I said, "You stupid motherfuckers." That's literally what I wrote down because I could not believe. Again, I had the expectation for Brandon to bring in these interviews and press runs. I did not expect to see it this soon.
Did they come back to you with something? I mean, how much do you remember?
I remember it, but I question, do I remember it because it's been relived so much? I mean, when I see the video of me driving from the waterfall, like what I just described, tapping the brakes when I crossed the intersection, Washington over Sherman Street, do I actually remember that I kind of slowly proceeded through that green light? No, I don't actually remember that. But I've seen the video so many times that you then question, did I remember on my own? Or was my memory jogged? But I also wondered, did I say, could I have hit him? Or was it told to me that I said I hit him? And I knew I never could have said that. So the closest I must have said was, did I hit him? I know I said I hit him, but did I really say this many times?
Wait, what? So she knows she said that she hit him. Hold on. I cannot get closed captions.
Me that I said I hit him, and I knew I never could have said that. So the closest I must have said was, did I hit him? I know I said I hit him, but did I really say it as many times as law enforcement's claiming I said it?
This is so stupid. It's so reckless. It is so amateur. It is absolutely unnecessary. It is unnecessary. It was unnecessary to begin with because Proctor was always going to be a problem for the prosecution. And the defense should have absolutely stuck to, they should have made Proctor their scapegoat. But this is just, I cannot, I don't know what this is. I don't know what kind of strategy this is. Make no sense.
Thank you. I now call Terry Roberts.
All right, so Carrie takes the stand. All right, so quickly to sum up, Carrie, so she was pretty much John O'Keefe's friend or acquaintance. And then by calling Carrie Roberts, the focus pretty much shifts to the victim or the decedent in this case, okay? Let's quickly move on to 310. I'm gonna have to fast forward because it's really, I still have to iron. Yeah, I still have to iron. So I'm gonna have to fast forward a little bit. Let's get to 310. Okay, that's
You were strangers?
Yep, that was the only time. I knew her. I knew of her. She has 4 girls, but I didn't know her.
At some point, as you were part of John's life, did you learn that he was dating a person by the name of Karen Reed?
Yes, I did.
And do you see that person here in the courtroom today?
Yes, I do.
Could you point her out and describe an article of clothing that she's wearing?
She has a black suit jacket seated at the front table.
When did you first become
all
familiar?
right. So that was the in-court ID, and again, here Brandon does not ask for the record to reflect that Carrie Roberts in fact pointed to Karen Reed. But let's move on. We want to get to 320. 320, or maybe Angie, you can listen to this.
Or know about Miss Reed?
July, I think it was, of 2020. John.
Okay, let's quickly go to 320. Is this it? No. All right, that's
And that was the beginning of the snowfall?
I believe so.
What was the weather out that night?
The weather that night, I think, was fine. It was cold, but it wasn't snowing yet.
I want to move forward ahead.
Yeah, and Carrie Roberts, I don't know if Allie's still up here. Allie, do you have snow tires? Carrie Roberts started off testifying about how no, she does not have snow tires because, I just recently got snow tires. I used to be a Carrie Roberts once upon a time. But apparently she's talking about no, she does not have snow tires because she has 4-wheel drive. Sure, Carrie. And then she saw, I believe somebody was slipping. Somebody's testimony, they were slipping and sliding in the snow or something along.
At some point that night, did you go to sleep?
Yes, I did.
Okay.
Did you sleep through the night, Ms. Roberts?
Yes, I did.
Okay. At some point, did you wake up?
Yes, I did.
I want you to tell us what was the reason that you woke up.
I got a phone call at 5 o'clock in the morning from Karen Reed.
Were you expecting a call?
No, I was not.
Had you ever received a call at 5 in the morning from Ms. Reed before?
No.
Share with us what happened that morning. What did you hear?
And this is what I liked about Brennan's direct. For the most part, he was not leading. He struggled a little bit with Carrie in some of the questions he was asking, but for the most part, he was not leading.
Karen called, and the first thing she said was, Carrie, John's dead. And then she hung up.
Okay, so those statements from Karen Reed over there, that's also pretty damning stuff, okay? What I was just trying to remember is, I guess I should have reviewed my notes before I came on the live. When I was watching this in real time, I was trying to figure out time, okay? I was trying to figure out a timeline. Because if this call is coming in at 5 a.m., is this call before or after EMS got on the scene? All right. Because it does make a difference. If Karen Reed is saying that John is dead prior to the discovery of his body, that is pretty damning. That is information that only the killer would know.
And then
When she said that, did you have a chance to have a conversation
Yay.
with her?
No, I did not.
Describe her demeanor.
Ellie, what kind of vehicle do you have? Tell me that. What kind of vehicle do you have? Do you have? Oh my goodness. I mean, I'm not judging though. I'm not judging. I used to be one of those people that was slipping and sliding in snow. I just got comfortable because I was driving through blizzards and stuff. I mean, that's irresponsible because I had my kid in my car. But I was driving through blizzards. I remember literally during my public defender days, it was obvious that we had inclement weather, but with criminal courts, you have to go to work. There was no way around it. People have to appear in court. So they made us go to work, and then around 1 p.m. they're like, "Oh, we need all of you guys to leave now because it's about to get pretty bad." The roads were already bad. I was literally slippy. I was determined though. I even went to a post office. I went to the post office and everything. I was slipping and sliding. So I'm not gonna judge. Not judging.
When she said that.
She was yelling loud enough, my name, I think it was 3 times, it might have been 2. She was yelling loud enough that she woke my husband.
Your husband was sleeping next to you?
Yes, he was.
Was she loud, yelling, screaming?
Yes, she was very loud. She was screaming.
After she said, Kerry, John's dead, did you know what she meant?
No.
And did you say this was around 5:15?
This was at 5. She called me at 5 on the dot.
After she hung up, what did you do?
I was half asleep still. I didn't know what was going on. So I started to get up, and I think I tried to call her back. I know I tried to call her back, but I don't know exactly when, because I was like, what? So my husband said, what was that? I said, I don't know. Something's going on. I don't know what's going on. That was Karen. And then I tried to call her back. I know I tried to call her back, but I don't know if she answered or if she called me back the next time I spoke to her.
After she called you again, did you have another discussion, or did you hear her say something else the second time you spoke to her?
Yes, the second time she said, I think something happened to John. I think he got hit by a plow. He didn't come home last night. Kaylee was home.
Again, that is problematic right there, okay? That is problematic because if this individual has not been found yet, and if you did not hit him, why do you think he could have potentially been hit by a plow? Well, that doesn't make sense.
He would never leave her by herself.
We'll see what cross-examination looks like and how Carrie Roberts holds up. I don't quite remember. I don't remember the cross-examination from the last trial.
And I was not supposed to stay at the house last night. So I think something happened to him.
Did she say anything about drinking?
Yes, she said, we drank so much, I don't remember anything from last night. And I said, okay, where are you now? She said, I'm driving. And I said, you need to go home. Where's Kaylee? And she said, at home. I said, you need to go home and be with Kaylee. She cannot handle this, thinking, her uncle's missing. I said, you're going to get a DUI. You need to go home.
Was there anything else in the conversation that she said to you at that time?
She said, I'm going to drive to your house. Would you drive my car? And I said, yes. So at that,
this part here, her offering to drive, I don't know, maybe I probably suffer from paranoia. Under no circumstances, after you tell me somebody's dead, you tell me you think they've been hit by a plow, they telling you they've been drinking, I'm not driving nothing. I'm not driving a single thing. I'm not driving a donkey cart. I'm not driving your vehicle. I'm not doing any. I don't even know. Listen, when I was in my 20s, I had some friends call me. They were out drinking. I don't know, I guess they were drinking, and then they started fighting amongst each other or something along those lines. I answered the phone after that. I stopped answering the phones, and I don't know that I've talked to them ever since then. But no, I'm not entertaining.
At that point, I started to get dressed. I turned on the automatic car starter so it would warm up.
All right, so let's quickly see. Let's quickly move on to 338. There were mentions of a broken tail light here. We're not going to get into that. Dang, girl, it's past your bedtime. All right, let's quickly move on to the search 338. This is way past my bedtime. I need to go to sleep. 338. That's me doing a whole lot of talking. Ooh. Oh, what did I do? So 338. I just did something. I don't even know what I did. Okay.
You recognize that?
That's John's car
Did.
or SUV. Stairs.
Okay, hold on.
Did she say anything?
No.
Did she
Okay,
do anything?
hold on.
Was she looking? Cave looking in rooms as well?
Okay, so that's, the testimony about them going to John's house and searching for him. And then let's quickly go to 343. 343, that's probably, I went too far. All right.
Backseat is now screaming. There he is. There he is. Let me.
Okay.
Tell us what happens.
As we approach Fairview at the house.
Okay.
You mean the house or the street?
Yes, the house.
The house. Jen said my sister's house is right up here, and I said okay. And as we approach the house, Karen from the backseat is now screaming, "There he is! There he is! Let me the f out of this car!" And she's now kicking the back door to get out.
When you heard the defendant scream, "There he is! There he is!" and started kicking the car door, did you see anything?
I did not.
Did you see anybody?
I did not.
Did you look?
I looked.
Was there anything that impeded your ability to see far?
No, it was just snow.
How far could you see when she was yelling, "There he is"?
How far could I see?
Yes.
I mean, the visibility wasn't great.
Okay. Was she pointing or giving any direction?
No, she just said, "There he is."
Okay. What happens next?
And then I unlocked the car. I looked over, I didn't see anything, and I unlocked it so she could get out of the back seat. I looked at Jen and I said, "She's crazy." And then I turned around and watched, and she ran over to a mound of snow.
When she started running, before she got anywhere, did you see anything at that point?
I did not.
Were you looking?
I was looking. She said, "There he is," so I'm looking around to see where he is.
And you could see nothing?
I did not.
Did you see her run around or directly?
She ran right over to the mound of snow.
Could you tell what the mound of snow was from the car?
Once she got to it, yes, it was. Once she got to it, you could tell it was a mound of snow that was the length of a body.
Okay.
All right, I'm going to stop you there.
That's pretty damning testimony there. All right. But the reason why I found interest in that is because visibility, we'll see the theme or issue of visibility come up over and over again. And Brennan is very deliberate in asking Carrie Roberts if she saw anything when Karen Reed said there is. And the reason why I think that if I'm looking at the same angle that he is, I think that this is going to come in later on when the snowplow driver testifies. Because if I remember correctly from the first trial, he did not see anything. So this Carrie's testimony might seek to explain some of that visibility, or at least what the conditions were on the day in question. But I thought, that was some pretty damning testimony. Overall, we've not gotten to cross yet. Cross-examination is really where you get to see if the story sticks or if it falls apart. All right, folks, it has been fantastic, but let me leave Benji with some words of wisdom. All right. So Benji said, let's go back here. So, okay, Benji apparently wants, Benji values my advice, okay? So my advice for Benji is, do I have real advice? Let me think. Let me give it Hold on. Can you please close the door? Thank you. All right. So my advice is pretty much don't lose yourself. I'll put it that way. Don't lose yourself in a relationship. All right. And I mean, you did say that there were healthy boundaries, or at least there's promise of healthy boundaries this time around. But don't lose yourself. Don't lose your identity. Do not lose, your dreams and aspirations in pursuit of a relationship. But that is not to say that you should not compromise. And you guys are young, Benji. All right. You guys are incredibly young. So if I told you how many people I thought I was actually going to marry, if I told you how many people I thought there would be my one and only and the last, that's not how it panned out. So that's typically advice that I have for younger folks. And that's also the advice that I plan on giving my daughter as she gets older. I don't exactly know that you should put your all into an individual, especially not when you're that young, because we change and we evolve over time, and we do improve over time. So yeah, that's my advice for now. And then Allie says, shout out to co-counsels. I want a real lawyer, public defenders, and the parenting parents. Just remember that you always want a real lawyer. Absolutely. Shout out to my co-counsels. We will reconvene tomorrow. I don't know. Does 8 p.m. work for you guys, or should we just go back to 8:30 p.m.? I think let's do 8 p.m. I was just up here for too long because I was doing a whole lot of rambling. But tomorrow, tomorrow let's do 8, and I'll try my very best to stick to the time constraints that I've set for myself. Tomorrow I cannot wait for Kerry Roberts cross-examination. Okay, so that works for Allie. I cannot wait for cross-examination. And then Allie, I'm gonna look forward to your email. You said you have some stuff to share with me. So I'm looking forward to that. And I need like a tag. I need like something to say when the show has ended, right? Eventually it will probably come to me. It will probably come to me. All right. And then Benji said, sounds good. Thanks, Essa. All right, folks. I love you guys. I am off. I'm not off to bed. I need to iron. But I'll talk to you guys tomorrow, 8 p.m. Eastern time. Shout out to the replay crew.